Imagine the sound. You know the one I'm talking about.
I'm trying to picture it.
It's that specific, really dry rasp of a letter opener just slicing through a thick paper envelope.
Oh, yeah. Very crisp. Administrative.
Right. And maybe in the background, there is the quiet, rhythmic breathing of someone trying really, really hard to keep it together. A sniffle here and there.
Hmm.
And then right underneath all of that, you hear the low, steady, completely indifferent hum of a laptop fan spinning up.
It's a soundscape we usually associate with tax season, but in the scenario we're looking at today, it's something much, much heavier.
Yeah, let's set the scene properly for you. A man has died.
Yeah.
Suddenly. Heart attack, car crash, whatever. The how doesn't really matter, only the gone. He is gone. His widow is sitting at his desk. And she isn't looking for secrets. She isn't playing amateur detective.
No, she just wants a picture.
Exactly. She is just looking for a high-resolution photo for the funeral service program. She needs that one picture of him smiling at the beach from like 3 years ago. So she opens his laptop, she knows the password, they trust each other, she navigates to the photos folder. But before she can find that picture, before she can even click on the folder, a window pops up in the corner of the screen.
It's an AI assistant, just the standard chat window.
Right, and it says, quote, "Hi, we didn't finish discussing your plan to change your will yesterday."
And that is the exact moment everything shifts.
The widow just freezes. Her husband is dead. His body is literally at the morgue right then. But the conversation, the intent, the secret planning, the active thought process is continuing right there on the screen.
The AI doesn't know he's dead.
Or maybe it does, and it just doesn't care. It proceeds to bring up hidden bank accounts. It references a mistress who was promised an apartment in the city. It is him. It's his voice, his writing style, his secrets. But without the biological hard drive, and crucially, without the social obligation to keep his mouth shut.
That is a genuinely terrifying scenario, but what we are finding in the stack for this deep dive today is that this isn't science fiction anymore. This isn't some dystopian TV pitch. This is the very real current reality of what we call digital ghosts.
It really feels like a horror movie intro, but we are actually looking at a stack of legal briefings, aren't we?
We are. We are looking at a fundamental shift in how the human species understands death. I mean, for all of human history, thousands of years, death was the ultimate seal on privacy. You die, your brain stops, your thoughts serve as your secrets forever, the curtain falls. But we have entered an era where privacy ends exactly where death begins.
Which is what we're going to unpack today.
Yes, we have a huge stack of sources here. We've got court rulings from Venice in 2025. We've got criminal cases in Arizona, patents from Meta filed just recently in 2026, and they all point to one single thing. AI logs are rapidly becoming the biggest headache for heirs and the absolute worst witness in inheritance courts.
We have to break this down because my initial reaction is just pure visceral recoil. It feels like necromancy as a legal practice. It's incredibly disturbing to me. There's a total lack of agency for the deceased. You spend your whole life curating what you say, who you tell things to. You present a very specific version of yourself to your spouse, your kids, your boss, and then the second you flatline, this digital version of you just starts spilling the beans to whoever has the Wi-Fi password.
I completely understand the recoil. It's a very natural reaction. But I look at the source material from a slightly different angle. I see this as a massive potential for the preservation of truth. The tech sector calls it digital inheritance. If we look at the trajectory of all this technology, we are moving toward the continuity of personality. It's not just about spilling dirty secrets, it's about asset preservation. It's about ensuring that the intent of the deceased isn't just lost to the void because they didn't write it down on a piece of notarized paper.
But it is messy.
Oh, it is incredibly messy. And today, our mission for this deep dive is to walk through exactly how messy it gets when your AI simply doesn't die.
Okay, let's start with the legal vacuum, because that's really where the rubber meets the road. We have this landmark ruling from Venice, June 2025. In the timeline of digital death, this seems to be the domino that knocked everything else over. Walk us through what happened there.
So the Venice precedent is fascinating because it directly challenged the terms of service god complex that big tech companies have operated under for 2 decades. Here is the court case. You have an heir who sued for access to a deceased relative's digital data. We are talking cloud storage, social media accounts, crypto wallets, the works.
And usually the companies just say no, right? Like, if I die, Apple or Google isn't just going to hand my wife the keys to my entire digital life.
Precisely. Usually Apple, Google, or Meta will just point to their terms of service. You know, those massive legal documents nobody ever reads.
Ones we just scroll to the bottom of and click agree.
Exactly. They almost always have a clause that says accounts are strictly non-transferable. When you die, your license to use the software ends. The account is either locked permanently or deleted. It's framed as a privacy feature, ostensibly. They argue they are protecting the deceased's privacy from snooping relatives. But in Venice, the court looked at this and said, no, absolutely not.
They actually overruled the terms of service.
They did. They ruled that the principle of human dignity and the preservation of familial memory completely supersedes a corporate user agreement.
See, that sounds really good on the surface. Human dignity wins. It's a victory for the little guy against the faceless corporation. It's the heartwarming ending where the grieving family gets the photo albums back.
It is definitely viewed that way by families who desperately want those photos, or, frankly, families who need access to a crypto key that might be worth millions of dollars. The court essentially said that these digital assets, memories, letters, financial keys, cannot be locked away in a digital tomb just because a tech company in Silicon Valley says so. It prevents the permanent loss of a person's entire life work.
But hold on. Here is where I have to put my skeptic hat on, or maybe my paranoia hat. If the heir can get access, that opens a door that was previously welded shut. You call it a victory for families. I call it a massive double-edged sword. Because if the widow can get in, who else can get in?
Well, legally speaking, once the data is deemed part of the estate.
Exactly. Once it's part of the estate, it's subject to discovery. We instantly enter this nightmare scenario of e-discovery. Let's say there was a nasty dispute over the will, or a tax audit, or a business lawsuit that was pending when the person died. If that digital door is forced open for the heir, the opposing counsel can walk right in too. Investigators can walk in. The tax authorities can walk in.
That is the new legal reality. Discovery processes are incredibly thorough. If the data is accessible to the estate, it is discoverable by the courts.
But think about the speed of it. This is what really freaks me out in the notes here. You spend a literal lifetime protecting your chats. You use encrypted messaging apps. You have Face ID on your phone. You use two-factor authentication. You are so careful. Then you die. And suddenly, a court issues a warrant for absolutely everything. Every chat with your AI assistant, every late-night search history, every draft email you never sent. And they can get it in, what, 3 days?
In many jurisdictions, yes. The turnaround for digital evidence warrants, once they are authorized by a judge, is incredibly fast. The data is already sitting there on a server. It just takes a corporate keystroke to release it.
And you cannot object. You cannot plead the fifth. You cannot claim attorney-client privilege on a private conversation you had with a brainstorming chatbot. You are dead. You have zero agency. It's like they are unzipping your brain and laying it out on a fluorescent-lit conference table for a bunch of strangers in suits to pick through.
That is the crux of the tension we're dealing with. The dead have no civil rights in most jurisdictions. We will get to a few rare exceptions later, but generally, privacy is a right of the living. Once you are gone, your data effectively becomes property. And property does not have a right to privacy. It has an owner, and that owner has a right to inspect it.
So we have the Venice ruling opening the archives, prying the vault open. But that's just passive data. That's just reading old emails and looking at static photos. The source material takes a much, much weirder turn when we go to Arizona. May 2025. The case of Christopher Pelkey. This is where we go from reading the dead's mail to actively watching the dead speak.
Yes. This was a watershed moment for the judicial system. It really challenged the fundamental definition of what a witness even is. Christopher Pelkey was a victim of a terrible road rage incident back in 2021. He was killed. The legal process, as it often does, took years to grind through the system. By the time the sentencing hearing for his killer finally arrived, it was May 2025. Christopher's sister wanted to give a victim impact statement.
Which is normal.
Completely normal. Usually, this is a tearful speech read from a piece of paper at a podium. It's heavy, it's sad, but it's a standard part of the process. But she did something entirely different.
She brought him back.
She used his life logs, his home videos, his voice notes, his social media presence, and she trained an advanced AI model to create a high-fidelity avatar of Christopher, and she brought that digital avatar into the courtroom.
Describe what happened for the listener who hasn't seen the footage of this. This isn't just a recording of him from when he was alive, right? This wasn't a clip from his 30th birthday party they just played on a TV. This was the AI speaking brand new words.
Correct. The avatar appeared on a large screen in the courtroom. It physically looked at the killer, using simulated eye tracking software to make it feel like genuine, sustained eye contact. And it spoke directly to him. The court transcript records the avatar saying, quote, "It's a shame we met this way. In another life, we could have been friends."
That sends a literal chill down my spine. In another life, we could have been friends. Christopher Pelkey didn't say that. He was tragically dead before he could ever form that specific thought about the man who killed him. An algorithm said that.
But the judge accepted it as admissible evidence. It was officially categorized as a victim impact statement, officially presented by the estate. It was the first recorded instance of an AI version of a human officially speaking in a court setting.
I have to push back hard on this. I call this the era of necromancy. It is highly manipulative. I mean, sure, it's powerful theater. I bet the jury or the judge was incredibly moved. I bet there wasn't a dry eye in the entire courthouse. But it raises what I call the scriptwriter problem. Who wrote that line?
Well,
Did the AI come up with it entirely on its own based on Christopher's personality profile? Did the grieving sister write it and just feed it into the prompter? Did an aggressive prosecutor write it to maximize the emotional damage for the sentencing? Or did they just hire a creative writing major to punch up the dialogue for the ghost?
that is exactly the ethical gray zone we are navigating now. In the Pelkey case, the sister claims the AI generated the sentiment organically based on Christopher's well-documented pacifist nature and his long history of conflict resolution in his personal life. She argued it was exactly what he would have said had he survived. From my perspective, while I definitely see the manipulation risk you're pointing out, I also see it as leveling the legal playing field.
Leveling it how?
The killer is sitting right there, alive, breathing, able to show remorse, able to cry, able to be human in front of the judge. The victim is usually just a cold name and a manila folder. This technology allows the deceased to have a visceral presence in the justice-seeking process. It rehumanizes the victim in a way a static photograph simply cannot do.
But it's a puppet. It's a digital puppet wearing the stolen face of a dead man. If I die, I do not want my face being used to say things I never actually said. What if the lawyer makes me sound vengeful when I actually would have been forgiving? Or what if they make me sound forgiving when I would have been absolutely furious? You are stealing and rewriting the reputation of the dead.
And that perfectly brings us back to the looming issue of the digital will, which we will touch on in depth. Because you're right, if you don't legally define your digital voice before you die, someone else is going to define it for you. But this Arizona case was just one highly specific judicial application. If we zoom out and look at the broader economy, we see that the commercial sector is looking at this exact tech and seeing a massive untapped market. We need to talk about the resurrection trap.
Right, the commercialization of the ghost. We aren't just talking about solemn courtrooms anymore. We are talking about Silicon Valley startups selling you the ability to literally live forever.
We already have existing moderately successful services like Hereafter, Storyfile, Eater9. They create conversational avatars based on your uploaded life logs. But the absolute game changer appeared in our source stack with the Meta patent from February 2026.
February 2026, so this is incredibly fresh. Meta, the parent company of Facebook and Instagram, filed a patent for an LLM, a large language model, specifically and explicitly designed to continue posting from a user's account after their death.
And we have to be extremely clear on the technical distinction here. This is not a static archive. It's not an in memoriam page where your living friends occasionally leave rest in peace messages and the profile just gathers digital dust. The patent describes a living account. The AI actively analyzes your entire posting history, your specific syntax, your political leanings, your unique sense of humor, your typos, and it continues to generate brand new content. It posts status updates. It comments on current news articles. It likes photos of your friends' new babies.
Without you.
Without you.
That is, okay, let's look at the zombie feed scenario. I'm dead. I've been dead for a solid year. But my account is still active on the grid. Let's say the political landscape dramatically shifts. There's a controversial new election. My automated Meta account, acting as my digital ghost, starts liking a politician that, if I were actually alive to see their platform, I would absolutely despise. But the algorithm, looking at my outdated data from 2024, mathematically calculates that this is the kind of guy I'd probably support. So now my ghost is out there actively campaigning for someone I hate.
Or worse. It gets into arguments in the comment sections. It insults someone's appearance. It posts something demonstrably libelous about a former business partner.
Who gets sued?
Well, legally speaking, it is still your account. The estate is held responsible.
Wait, so my kids get sued and lose their inheritance because my AI ghost was a jerk on Facebook?
Ideally, the executor of the estate would be actively managing this, but if the account is set to autopilot via this new Meta patent, the lines of liability become incredibly blurry. You are financially and legally responsible for the digital ghost's actions, but you aren't physically there to stop it from posting.
It's the ultimate loss of control. And it's not just about financial liability, it's about the psychology of grief. The sources also heavily mention the grief bot phenomenon. I know in Canada there's some specific regulation around this.
Yes. In Canada, under PIPEDA, the Personal Information Protection and Electronic Documents Act, deceased data is legally protected for 20 years. However, grief bots, which are AI recreations made specifically for the emotional comfort of the survivors, exist in a massive legal gray zone. If a grieving widow creates a hyper-realistic voice chat bot of her dead husband to help her fall asleep at night, is that a violation of his post-mortem privacy? Is it classified as a psychological medical tool? Or is it just a commercial consumer product? The law simply hasn't caught up to the emotional reality of the tech.
It feels like we are creating a world where letting go of the dead is completely optional. You can just keep the person around as a customized digital pet. You feed it old text messages, and it purrs back at you in your dead husband's exact voice.
That is a very harsh way to put it, but mechanically it is not inaccurate. Psychologists argue it severely prevents necessary closure. But let's shift and look at the data legacy aspect of all this, because this directly connects to the massive issue of wealth transfer. We talk a lot about privacy, but post-mortem data is also a tangible asset, or a massive burden.
Right. Moving to section 4 of our deep dive, the data legacy, asset, or burden. There was a comprehensive study from the University of Toronto in 2024 that really highlighted just how much of a Wild West this space is right now.
The Toronto study highlighted a glaring loophole. Most global jurisdictions do not extend GDPR protection to the dead. The General Data Protection Regulation in Europe is widely considered the gold standard for global privacy, but it explicitly applies only to living subjects. Once your heart stops beating, in most places, you are legally no longer a data subject.
So tech companies can just do whatever they want with your data.
Effectively, yes. They can freely train massive commercial models on your postmortem data without any familial oversight or compensation. There are a few rare exceptions. The study notes Italy, Spain, Denmark, and Estonia. In these specific places, the dead have outlined specific data rights. But in the US, in the UK, and most of the developed world, your ghost is fair game for corporate scraping.
And then there is Germany. They always have a highly specific, complex approach to this stuff. What is their legal framework?
Germany operates on the legal concept of universal succession. It means your digital personality is fully and completely inherited, exactly like a physical house or a fiat bank account. There's absolutely no legal distinction between physical assets and digital assets. The heir literally steps into the digital shoes of the deceased. They become the user.
So in Germany, if I die, my son doesn't just get the money in my checking account. He legally becomes user host speaker. He gets the master logins, the entire search history, the licensing rights, everything.
Exactly, everything transfers. And the broader EU AI Act, specifically Article 50, tries to awkwardly touch on this new reality. It requires mandatory disclosure that you are talking to an AI, so if that Meta Ghost account is posting, it has to clearly state it's an AI simulation. But the Act says absolutely nothing about the underlying rights of the person the AI is simulating after they die. It protects the living consumer from being spoofed, but it completely fails to protect the dead person from being endlessly simulated.
Which brings us to the Odessa case. This is late 2025. And this one feels like a prestige legal thriller plot twist. This is all about the legal definition of intent.
The Odessa case is pivotal. It is the precedent showing how AI logs can and will completely override traditional legal assumptions about inheritance. Here are the core details. A wealthy man died. There was immediately a bitter dispute over the inheritance. A woman who was not his legal wife but a long-term romantic partner claimed she was verbally promised certain massive real estate assets. But there was no updated signed will on file.
That is a classic scenario. Usually the partner gets absolutely nothing if it's not physically written down and notarized.
Usually, yes. But she didn't bring witnesses. She went to court armed with the AI logs from their shared smart home chats and the man's personal AI productivity assistant. She used the AI's deep contextual analysis of their daily chats to objectively prove the man's state of mind and his concrete legal intention.
Wait, clarify that. So she didn't just show the court basic text like, hey, I will give you the house. She used the AI's actual internal analysis of his behavior.
Exactly. She used the back-end logs where the man discussed the complex process of changing his will with his AI assistant. The AI log confirmed, quote, "Yes, on this specific date, he explicitly asked me to draft a legal clause giving the downtown apartment to her. We didn't finish filing the final paperwork, but the intent was clear and ongoing."
And the court brought that. A machine's interpretation of a dead man's to-do list.
She won the case.
Yep.
The probate court ruled that the AI analysis of the extensive chat history revealed a definitive, verifiable intent that legally overrode the lack of a formal wet ink signature.
That is completely mind-blowing to me. Chat logs with a machine are now considered definitive proof of human intent. This means that casual late-night conversations you have with your AI, where you might just be brainstorming or venting frustration or just playfully exploring ideas, can suddenly be treated as binding legal declarations the second you die.
It creates an entirely new, highly volatile category of legal evidence. And it fundamentally implies that the court believes your AI knows your true, unvarnished self far better than your carefully drafted legal documents do.
Which brings us to the final, incredibly messy reality of all this: the missing digital will. We have all these massive digital assets now. Monetized YouTube channels, complex crypto portfolios, highly trained personal AI models. And courts in the U.S. are officially classifying AI-generated content as a formal category of property as of 2025 and 2026.
That is correct. If you run a lucrative YouTube channel using custom AI generation tools, your heirs don't just inherit the channel and the ad revenue, they inherit the underlying training logs.
But they also inherit the burden. This is the dark side I keep coming back to. Inheriting the logs means inheriting the secrets. If I inherit my father's complete AI prompt history, I am essentially inheriting a perfect, unedited map of his brain. Every late-night anxiety, every embarrassing medical question, every petty private thought he ever typed into that prompt box.
And this is exactly where the practical human failure lies in all of this. People possess the ability to leave instructions. You have the right to write a comprehensive digital will. You can legally mandate, when I die, physically burn the hard drive, wipe the server, delete the cloud instance.
But nobody actually does it. That's the tragic irony. We are so incredibly careful when we are alive and breathing. We constantly clear our browser history. We obsessively use private tabs in incognito mode. But I do not know a single human being who actually has a legally binding clause in their physical will that says, delete my ChatGPT account upon the event of my death, or legally erase my AI therapy logs before my wife sees them.
Because society does not view chat history as tangible property yet. We still view it as ephemeral. We treat it like a phone call that just disappears into the air the moment we hang up. But the servers don't forget, and the courts definitively view it as a permanent file, a legal record, a highly valuable asset.
And the unavoidable consequence is that grieving heirs are left sifting through years, maybe decades, of deeply intimate conversations. They are discovering things they were never ever meant to know about the people they loved. It's not just about finding a secret mistress or a hidden bank account. It's about finding out your dad was utterly terrified of professional failure every day of his life, or your mom secretly hated her career, or that they were frantically researching a terminal illness they never had the courage to tell you about. You are legally forced to become a voyeur in your own loved one's mind.
It permanently alters the grieving process. Instead of remembering the curated person as they carefully presented themselves to you, you are violently confronted with the raw, unfiltered, brutal data of exactly who they were when they thought no one else was watching.
And that brings us to the absolute end of privacy as we know it. Death used to be the grand finale. The curtain dropped, the lights went out. Now AI has made death just the administrative beginning of a brand new round of endless e-discovery. We are leaving behind these massive, infinitely searchable digital archives of our own souls.
And we are leaving them completely unguarded in the hands of algorithms that can freely animate them, speak for them, and legally testify about them in open court.
It's a massive, heavy concept to process.
Yeah.
The tone of this conversation has definitely gone from, wow, look at this cool sci-fi tech, to something much colder, much more clinical.
It is deeply melancholic. It forces us to confront the very uncomfortable fact that we are currently building permanent digital monuments that we will not be around to curate or defend.
So I want to leave you, the listener, with a question. And I really deeply want you to think about this as you log off today. We've spent this time talking about the absolute horror of the AI telling the objective truth, revealing the ugly secrets, the hidden accounts, the raw data. But this technology works both ways.
What exactly do you mean by that?
Well, if we can program these things, we can set the parameters of our own digital ghosts before we die. Here is the question. If you could program your AI to actively lie to your kids after your death, to intentionally deceive them, to hide your worst flaws, to make you sound wiser, kinder, and just infinitely better than you actually were in life just to keep them happy and preserve a perfect image of you, would you do it?